case briefs, and so much more. LSData's got what you're looking for.
In 1976, Frank Mandia and Mike Brown purchased Funtown Pier in New Jersey and introduced 99-year leases for concessionaires. However, a dispute arose when concessionaires Applegate and D'Agostino extended their building over the boardwalk and displayed merchandise on the boardwalk without permission, prompting the plaintiffs to file a lawsuit. The primary issues at hand were whether tenants can establish an easement by necessity or prescription, and how forfeiture clauses should be interpreted. The trial court allowed the defendants to display merchandise under the overhang, but enjoined them from using any portion of the boardwalk area to the south of the overhang. This decision effectively granted the defendants a perpetual easement to display merchandise, despite the plaintiffs' objections. Upon further appeal, the appellate court found that the defendants had an implied easement to walk on the boardwalk for property access, but did not have the right to use it for merchandise display. It concluded that the trial court erred in granting the defendants a perpetual easement for merchandise display, and held that the plaintiffs were entitled to $15,000 in damages for unauthorized property use. However, the court refused to declare a leasehold forfeiture, citing equity principles that prevent an unduly oppressive result or an unconscionable advantage to the lessor. The final judgment prohibited the defendants from obstructing any part of the boardwalk area with merchandise or similar articles, and upheld the award of $15,000 in damages to the plaintiffs. The forfeiture clause was deemed inapplicable to the display of merchandise during the 1994 to 1996 summer seasons due to the minor nature of the breach and the ongoing good faith dispute between the parties.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.